When a state government spends tax revenue in a 1.5 billion naira to marry off 1,500 couples, and not just that, it is celebrated in a state wherein a 17-year-old is married off as a wife.
This is my first marriage. Okay. And I'm not married widow. I'm married 17 years old. I'm very happy today.
Where does social welfare end and where does illegal public spending begin? Let me explain this. The Kano state government at the Emir's Palace sponsored a massive 2-day wedding involving 1,500 couples. Under the initiative, it gave out 100,000 naira for dowry, 100,000 naira for business sponsorship of the bride, provision of furniture, food, and other items. The state government explained this as a social intervention aimed at providing financial support to the low-income earners and to support families who are struggling. However, from the public finance law perspective, Chapter 2, Section 16 of the 1999 Constitution mandates that state economic policies must be directed towards securing the maximum welfare, freedom, and education of all citizens. Legal analysts highlight a stark statutory irony. Allocating 1.5 billion naira to state-funded weddings, while capital allocation for out-of-school children and basic education infrastructure receive only a small fraction of this money. The controversy also intensifies when a viral clip shows a groom thanking the state government for aiding him to marry a 17-year-old bride. This brings a major conflict in Nigerian laws. Under Sections 21 and 22 of the Federal Child Rights Act of Nigeria, 2003, any marriage involving a person under the age of 18 is expressly prohibited, legally null and void, and carries punishment for those who practice, promote, or facilitate it. Furthermore, international human rights treaties, which Nigeria is a signatory to, including Article 6 of the Maputo Protocol and the African Charter on the Rights and Welfare of Children, establish the 18-year benchmark for marriage of children without any exception. So how does this happen under a state sponsorship? Legal reality comes from Nigeria running a tripartite legal system. It means that both the federal statutory laws, the customary law, and the Sharia law all operate in Nigeria at the same time, depending on the region. While the Federal Child Rights Act sets the age at 18, Section 29, subsection 4b of the 1999 Constitution of the Federal Republic of Nigeria states that any woman who is married shall be deemed to be of full age. In states operating Sharia law, the maturity for marriage is traditionally evaluated by puberty or traditional norms and culture rather than the strict statutory 18-year rule. Even under Kano's state-level protection law, legal exceptions exist, allowing a person under 18 years to marry where customs and practices allow this. This creates a prolonged legal paradox. The state government executing a public program while breaking the federal law and international treaties which the federal government is a part of. The Kano state wedding raises concerns regarding governance and public accountability. Is it a legal duty for a state government to act as a matchmaker and spend billions in public tax revenues in celebrating private marital ceremonies? Or should public funds be legally restricted to healthcare, education, and creating jobs so these persons can make money and marry for themselves? Should federal child protection laws override state exception where public funding is involved? Make sure you like this post, you share, and you comment. I want to hear your thoughts.